Right now, on the device in your hand, there are contracts with your name on them that you have never read. Not one line. You agreed to all of them anyway. Every app you installed, every account you opened, every box you had to check before the button lit up, each one made you a promise, and made you promise something back. And here is the part that should stop you cold. If you ever tried to fight one of those agreements in court, there is a very good chance a judge would look at you and say, "You signed this. You clicked, I agree." That click is your signature. It doesn't matter that the text was 40 pages of dense legal language. It doesn't matter that nobody on earth actually reads it. You said yes. Studies have quietly confirmed what we all already know. Almost no one reads the terms and conditions. And yet those unread walls of text can decide whether you're allowed to sue a company, whether you ever see the inside of a courtroom, whether you can join with thousands of others who were harmed the same way. So how did we get here? How did a tiny box you tick without thinking become as binding as ink on paper? The answer isn't in some grand Supreme Court showdown. It's in a couple of strange, almost forgotten lawsuits, one about a box of software, one about a free download, that quietly rewrote the rules of agreement for the entire internet. Let's open the fine print. Go back to the 1990s, before everything lived in the cloud. Software came in a physical box on a store shelf. You paid your money at the register, carried it home, tore off the shrink wrap, and only then, inside the box, printed on the papers or flashing on the screen during install, did you finally see the license terms. The rules of use. The fine print. And this created a genuinely tricky legal puzzle. Think about it. In normal contract law, you agree to the terms of a deal before you pay, not after. You know what you're buying when you hand over the cash. But here, the customer paid first and saw the rules second. So were those hidden until later terms actually binding? Or were they just a wish list the company slipped in the box, with no real power? A man bought a piece of software, a database of phone listings, and the license inside said, clearly, that it was for personal use only. He ignored that. He took the data, put it on a website, and started charging people to access it. The company sued. And his defense was beautifully simple: I never agreed to those terms. They were inside the box. I couldn't read them until after I'd already bought it. You can't hold me to rules I only saw after paying. It's a genuinely good argument. And a lot of people assumed he would win. He did not. In 1996, the court in the case known as Procedi vs. Zeidenberg reached a decision that would echo for decades. The judges said the license was enforceable. The terms inside the box counted. And their reasoning is the hinge that the entire modern internet swings on. The court said, buying the software wasn't the final, locked-in moment of the deal. It was the beginning. The company had effectively made an offer with a condition attached: you can use this, but only if you accept these terms, which you'll see when you open it. And crucially, the buyer had a way out. When those terms appeared on his screen, he could have clicked, I do not agree, returned the software, and gotten his money back. He didn't. He clicked to accept, and then he used the product. By doing that, by going forward instead of walking away, he showed his agreement through his actions. In the eyes of the law, that was assent. That was him saying yes. Sit with how big that is. The court just ruled that you can agree to a contract you were shown only after you paid, simply by choosing to keep using the thing instead of returning it. The physical act, clicking accept, installing, moving forward, became the signature. Not a pen. Not your name. A choice to proceed. And once a court blessed that idea for a box of software, it was only a matter of time before it wrapped itself around every button on the internet. But here's where it gets interesting, because this is not a story about companies always winning. There's a second case, and it draws the line that protects you. Fast forward to 2002. A company called Netscape offered a free piece of software you could download off their website. Free. One click, and it started downloading. But buried further down the page, below the download button, in a spot you had to scroll to even notice, was a link to the license terms. And those terms said that if you used the software, you agreed to settle any dispute through private arbitration instead of going to court. Users downloaded the free program. They never scrolled down. They never clicked on those terms. They never even saw them. Later, some of them wanted to sue over what the software did, and the company said, "Sorry, you agreed to arbitration, it's right there in the terms." And in the case known as Spect versus Netscape, the court said no. This time, the fine print did not bind anyone. Why the opposite result? Because of one word that turns out to be everything: notice. The terms were there, technically, on the page, but a reasonable person clicking that download button had no clear signal that agreeing to anything was even happening. There was no box to check. No, I agree. Nothing forcing your eyes to the terms before you acted. You could download the whole thing without ever knowing a contract existed. And a hidden agreement you never had a fair chance to see, the court ruled, is not an agreement at all. So now we have the full picture, and it comes down to two ingredients. Put them together and you're bound. Miss one, and you might walk free. The first ingredient is notice. Were you clearly told, in a way a reasonable person couldn't miss, that terms existed and that continuing meant accepting them? A giant "I agree" button you have to click before proceeding, that's loud, unmissable notice. A faint link hiding below the fold that you can scroll right past, that's not. The second ingredient is assent. Did you actually do something to say yes? Clicking a box that says, "I have read and agree," that's an affirmative act of agreement, even if you're lying about the reading part. Simply using a website whose terms sit quietly in the footer, that's much shakier ground. Lawyers gave these two patterns names. When you must actively click, "I agree," before you can move on, that's called click wrap, and courts love it, because the notice is clear and the click is your assent. When the terms are just sitting there in a link and the company claims you agreed by merely browsing, that's called browse wrap, and it's a coin flip that companies often lose. This is why, today, every serious app and website makes you tick a box or tap a button. They learned the lesson. Make you click, and they've got you. That's the whole game, and it's the reason your screens are full of those little checkboxes standing between you and whatever you're trying to do. Now for the part that actually reaches into your life. If a click can bind you as tightly as a signature, the only question left is, what exactly did you agree to? And the answer is hiding in clauses most people have never heard of, buried deep in text they never read. The big one is called an arbitration clause. In plain language, it means this: if the company wrongs you, overcharges you, mishandles your data, sells you something broken, you have agreed, in advance, to give up your right to take them to a real court in front of a real judge and jury. Instead, your complaint goes to a private arbitrator, often in a process the company itself helped design. You surrendered one of your most fundamental rights, and you did it by clicking a button to install a game. There's a second clause that travels right beside it, and it's arguably worse: the class action waiver. Normally, if a company does something small but wrong to millions of people, quietly overcharges everyone $1 a month, those millions can band together into one massive lawsuit. No single person's dollar is worth fighting for alone, but together, they're a force a corporation genuinely fears. The class action waiver kills that. It says you agree to come at them only by yourself, one tiny person against an army of lawyers, over your $1. Alone, you'll never bother. And they know it. That's the point. These aren't hidden because they benefit you. They're hidden because reading them might make you hesitate, and hesitation is exactly what that glowing, "I agree" button is designed to eliminate. So let's put the whole thing together. 2 quiet lawsuits, one about software in a box, one about a free download, became the foundation for how agreement works in the digital age. One taught us that moving forward instead of walking away can count as saying yes. The other taught us there's a limit, no clear notice, no real chance to see the terms, no deal. And between them, they handed companies a simple recipe. Show the terms. Add a button. Make you click it. And once you do, the law treats those 40 unread pages as if you'd studied every word and signed at the bottom. The system isn't secretly illegal, it's ruthlessly legal. It works exactly as designed. The genius, and the trap, is that it's built entirely around your own impatience. You're not tricked into agreeing. You're invited to, and you say yes, because reading would cost you 3 minutes and the button is right there, glowing, one tap from what you actually want. So here's what I want to leave you with. The next time an app throws up that wall of text and dares you to scroll to the bottom, that little box you tick without a thought isn't a formality. It's your signature. It's you, on the record, agreeing to terms you chose not to read. So I have to ask you honestly, knowing everything you now know, that a single click can strip away your right to sue, your right to join others, your day in court, would you actually start reading them? Or would you click, "I agree" anyway, just like the rest of us? Tell me the truth down in the comments.